I read every one.
Ms. Amara?
That's my understanding as a lawyer.
Ms. Baton, have you heard what the attorneys have said the resolution of this case is?
Yes, Your Honor.
And is that how you wish to resolve it?
Yes, Your Honor.
Please raise your right hand. You solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
It's my understanding that you'll be pleading guilty essentially as charged to count number 1 of domestic violence, which is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. Now, you have a sentence agreement with the prosecutor that I would sentence you under 4A, which is a reference to the statute. But what that essentially says is that I would put you on a period of probation. And as long as you're successful with that probation, this charge would not show on your public record. It would show on your law enforcement record and your court record. So we would be able to see it, but anybody running your public record would not. Do you understand that?
Yes, Your Honor.
Now, do you also understand that that is an agreement you have with the prosecutor? That's not an agreement you have with me. So if I decided that I was not going to follow that agreement, you would be able to withdraw your plea and we'd come back here and start over again. Do you understand that?
Yes, Your Honor.
Knowing all that, then, do you still wish to enter the plea today?
Yes, Your Honor.
Back on June 21st of this year, were you on probation or parole?
No, Your Honor.
Were you on bond?
No, Your Honor.
Do you remember reading and signing this advice of rights form? Talk about your rights to an attorney and your rights to a trial.
Yes, Your Honor.
Did you understand those rights?
Yes.
Most importantly, do you understand that you have a right to have a trial, and by entering a guilty plea today, you'll be giving up that right. You won't have a trial of any kind.
Yes, Your Honor.
Other than the plea agreement, has anybody promised you anything in order to get you to plea today?
No, Your Honor.
Has anybody threatened you in any way?
No, Your Honor.
And is it your own free choice to plead?
Yes, Your Honor.
Are counsel aware of any of their promises, threats, or inducements not made part of the record?
No.
No, Your Honor.
Then, Ms. Baton, to the allegation that on or about July 21st, 2025, I said June 21st, 2025, in Cedar Creek Township of Wexford County, how do you plead to domestic violence?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on that date, were you in Cedar Creek Township?
I was.
And did you have some sort of relationship with a Nicholas Carstens?
I did.
What was that relationship?
We were boyfriend and girlfriend.
Were you at that time?
Yes, we were at that time. We are no longer boyfriend and girlfriend. We
All
were
right.
at that time.
And what happened that night? What did you do?
It was in the morning, 8:30
Okay.
in the morning.
Sorry.
He had been drinking, and we were going through a separation. I was trying to move out of the house. I was moving some of my things. He had his own vehicle. I had my own vehicle. He grabbed my keys and walked out of our sliding glass door. I went after him and grabbed my keys back from him. He followed me back into the sliding glass door. I put my hand up like this onto his chest and pushed him backwards, and then I slapped him in the face, and then he called the cops.
And why did you do that?
Because he was advancing towards me, coming in the door, and I just wanted him to stay out of the door. I told him to leave, get your own keys and leave. Since you've been drinking, you can take your own vehicle and leave, but I don't need you taking mine. I'm a single mom of 3 kids. They were all there. I didn't want him to continue to go towards my kids. So I put my hand up, I slapped him in the face. I said, back up, go away. And he walked outside and said, I'll make you pay for this, and called the cops.
And when you did that, what was
Yes.
going through your mind?
I was afraid that he was gonna come after me or my kids. He had a previous personal protection order against his ex-wife. So I just wanted him to stop. I wasn't trying to physically hurt him. I wanted him to stop advancing towards me and my children.
And what was his demeanor like when you did that?
I feel like just wanted me to get in trouble. I think he wanted me to do something so that he would make me go to jail, honestly.
Was he acting in a certain way or saying
I mean,
something?
he was very red-faced, very angry. He normally has an alcohol issue, so it's not out of character for me to see him like this, but
When you say he was very angry, can you describe that some more? for me?
bloodshot eyes, just veins popping out of his arms. I mean, he's 6'4", I'm 5'3", he weighs 250 pounds.
Was he saying anything?
I'm gonna make you pay for this.
That was before or after you?
He said it twice, before and after. As he was coming in the door and my hand was on him, he said, I'm gonna make you pay for this. So I slapped him, and then he said, I'm definitely gonna make you pay for that.
Now, you had said something along the lines, and I can't remember your exact words, but you were essentially sounded like you had some fear as to what might happen.
Yeah,
Can you describe that some more for me?
I just didn't want my kids to get hurt or him to do anything to me. When he was going through his divorce, his previous divorce, he choked his ex-wife. That's why she had personal protection orders against him. I was afraid that he was going to do something like that to me. And
Did he make any outward motions or say anything that made you think that that would happen?
just walking very fast and briskly towards me and continue, like I said, he's 6'4", 250 pounds. When you're coming at me, like with your chest pushed out, it kind of just, like I said, scared me. And I just wanted to get him away from me. I wasn't trying to physically, obviously I can't physically hurt him. He's way bigger than I am, but I just wanted him to get back away from where I was and where my children were.
Counsel, I don't believe I can accept that plea. You want some more time to regroup on this? I'm willing to set it over for a status conference next week if you want to do that.
I'm fine with the people. No, absolutely not.
I would rather be set for trial.
All right. So, Ms. Baden, so it's through no fault of your own. You've done nothing wrong. You've told me as you perceived the events that night. It's just that based on what you've told me, I'm not able to accept that plea.
Okay,
So, what your attorney is requesting that we do then is to set the matter for a trial.
okay,
At that trial, the prosecution would have to prove your guilt beyond a reasonable doubt.
which, and that's what they told me, and I mean, I did slap him in the face, and so that's
Well,
what they said.
so, I mean, I can't give legal advice at all.
Right.
But the way you've expressed it to me,
Yes.
it's possible that there's a defense there.
That's,
And that would be up to the jury to determine whether or not me, but that's up to the jury to determine whether or not that's an applicable
yes,
defense.
and that was,
And so it looks like we'll be setting the matter for a trial.
that's
then.
fine.
Ms. Carey, are you aware of any issues for trial?
Yeah.
Ms. O'Mara, are you aware of any issues for trial?
I don't. So I know Nicholas Carson is a former client of ours. I don't know if he's, no, I don't see an issue. I just wanted to mention that he's a former client of the public defender's office.
Ms. Carey, I know Ms. Baton has mentioned some possible 404 things. Were you aware of those before today?
Not today, because I didn't look at me today.
Do you anticipate any 404 filings?
I can give you her name.
That's not up to you. Oh, wait, I'm sorry. No, that would not be up to you. That'd be up to, okay. Sorry. All right. So we are, today's final pre-trials are being scheduled for October 17th, and I believe this is the only trial we've got so far. So the court will go ahead and we will schedule this for trial on the 17th of October. If something happens between now and then, I will take a plea in this case, just because of the situation that it is. So I will take a plea if the parties decide that they work around any issues that we have. So we will set this for trial. Just making some notes. Well, Ms. O'Mara, you mentioned that your office had previously represented the alleged victim in this case. Do you believe there's anything that in that representation that rises to a level of a conflict?
Not from my personal experience or it's not a conflict for me. I don't know that it would be a conflict for someone else in the office.
I'm seeing Mr. Harrison shake his head and Ms. Firavento shaking her head as well. So I'll take that as of right now, we're not anticipating a conflict.
I'm not knowing the details in general, Your Honor. If there is a prior file that is now closed and it's unrelated to the prior file in any way, our office does not consider that a conflict. It is only if there's a current open file, such as he was a defendant in another case, then it would be a conflict.
Or if anything, learning that representation would be used against him in this case.
We don't
So-
believe that to be a realistic possibility.
All right. So as of right now, the court will treat it as if there is no conflict, but certainly if the parties discover a conflict, I'm going to request that be brought to the court immediately so we can look into that. Okay. Ms. Baton, just a reminder that your bond conditions continue. You can go out to the front window where you checked in and get your next court date, which will be the trial date.
Okay, thank
All
you,
right.
Your Honor.
Make sure you stay in touch with your attorney.
Thank you.
This is case number 253336 ST, appearances counsel.
Joanna Carey for the people.
Even O'Mara on behalf of Ms. Nash.
And we are here for a final pretrial conference. Is there any resolution?
Yes, Your Honor, my client is to plead no contest to as charged.
Ms. Carey? And the purpose for the no contest plea?
Civil liability.
Is there a restitution requested in this case?
There isn't restitution requested, but the victim would be a child who was struck. So we just want, in case that comes up in a civil matter, you know, it's a civil.
No, it's not a victim notification case,
So
so whether there's restitution or not. I think the child was taken to the hospital. I'm not sure there was injury. I think we checked out. We didn't report it, so.
I have the report.
I,
But the defense does. I gave them my report.
do you mind if I-
So, yeah, is it marked already? So just so I'm clear, there was a victim from the accident was taken to the hospital for medical. We just don't know whether there's restitution. All right. Ms. Nash, have you heard what the attorneys have said the resolution in this case is?
Yes, sir.
And is that how you wish to resolve it?
Yes, sir.
Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may put your hand down. It's my understanding that you'll be pleading no contest to the charged offense of failed to report an accident. That is a misdemeanor punishable by up to 90 days in jail and or a fine of $100. Is that your understanding of the plea agreement?
Yes, sir.
Now, a no contest plea is a plea that essentially means that you are accepting guilt without saying that you're guilty. And there's only certain reasons a court can take that. And in this case, I'm being told that from the attorneys that it's potential civil liability because there was some injury or possible injury in this case that you might be responsible for reimbursements for. And so in order to accept the plea, the court would then be reviewing a document. In this case, it looks like it's going to be a police report to determine whether or not there is enough evidence to support the plea and to find you guilty and for sentencing purposes. Do you understand that? Yes.
Yes.
All right. Yeah. All right. Back on May 22nd of this year, were you on probation or parole?
What was that?
Were you on probation or parole back in May?
No,
Were you on bond?
yes. Because of the situation from what I.
So when the event happened, you weren't on bond, is that
No.
correct? All
No,
right. Do you remember reading and signing this advice and rights form? It talked about your rights to an attorney and your rights to a trial.
yes, sir.
Did you understand those rights? Most importantly, do you understand that you have a right to have a trial, and by entering a no contest plea today, you'll be giving up that right and you won't have a trial of any kind? Yes? Knowing that, then, do you still wish to enter the no contest plea?
I'm sorry.
Do you still wish to enter the no contest plea?
Yes,
Other than the, well, I guess we don't have an agreement. Has anybody promised you anything in order to get you to plea?
no, sir.
Has anybody threatened you in any way?
No,
And is it your own free choice to plead today?
yes,
Then to the allegation, I'm sorry, counsel, are either of you aware of any other promises, threats, or inducements not made part of the record?
No,
No, Your Honor.
Then Ms. Nash, the allegation that on or about May 22nd, 2025 in the city of Cadillac, how do you plead to fail to report an accident? I anticipate
Guilty, sir.
to be a no contest
I'll
plea.
say, no, that's fine.
All right. Counsel, I've been provided with what's been marked as People's Exhibit number 1, which is a Cadillac Police Department report, incident number 25-001354. Ms. Carey, are you moving for a submission?
and
Ms. O'Mara, any objection?
No objection.
All right, give me, People's 1 is received. Give me a All right, counsel, I've had the opportunity to review People's Exhibit number 1. Do you believe it provides a factual basis in which to accept the plea and that the court rules have been complied with?
I do.
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Ms. Nash, I find you guilty of failing to report an accident. In particular, People's Exhibit number 1 makes out that in the city of Cadillac on Lake Street on May 22nd of this year, there was an incident in which I believe correctly, 5-year-old boy had run across the street from behind a pickup and was struck by a vehicle driven by Ms. Nash. Ms. Nash, through some investigation, was identified and interviewed by law enforcement, where she admitted to striking the child, admits that she didn't see him until the last minute because he ran behind the pickup truck going in the opposite direction. And she did assume the man that was assisting the boy was the father, but he never spoke with her. She eventually leaves the scene because the father would not speak to her and that she was scared. The other witnesses reported that the boy had bruising and had been cut up and had blood. This came to the attention of law enforcement while the victim was at the Munson Hospital for treatment. As such, I find there is a factual basis to accept the plea. Additionally, I find the interests of justice are well served in allowing the defendant to enter a no contest plea to avoid any potential civil liability that may arise out of this case. Ms. Carey, is there any victim input?
There isn't, as I said, it's not.
Oh, there is no victim rights were given. I am going to, on my own, adjourn today for sentencing. Ms. Carey, I know this is not a crime victims' rights case, but I think in this type of case, I think it would be appropriate to at least reach out to them to see whether or not there's anything that they would like the court to know. I'm also going to order a PSI in this case. So we will set this out for 2 weeks. Ms. Nash, just a reminder that your bond conditions continue. You can go out to the front window where you checked in and get your next court date. Okay, thank you.
Your Honor, I know pre-sentence investigation reports are typically done through the circuit court.
The district court probation does them for me.
All right, let's talk about that. This session brought us 2 very different cases. One domestic violence plea that didn't quite stick, and one no contest plea for failing to report an accident that carried serious real-world consequences. Judge Middleton, true to form, kept things professional, patient, and careful to balance the law with common sense. Was Miss Bateman, who came prepared to plead guilty to domestic violence under a deal that would have kept the conviction off her public record if she completed probation. But when Judge Middleton pressed her for the factual basis, her story painted a different picture. she admitted to pushing and slapping her boyfriend during an argument while trying to stop him from taking her keys and advancing toward her children. She described herself as afraid, citing his size, past behavior, and angry demeanor. Her words sounded less like a confession to a crime and more like a defense of protecting herself and her kids. That was the sticking point. The judge explained that based on her own description, he couldn't accept the plea. Without a clean admission of guilt, it didn't meet the standard. He offered more time to regroup, but Bateman and her attorney opted to head to trial instead. The moment was striking, a defendant trying to resolve her case quickly, but unintentionally raising the possibility of a self-defense argument that could resonate with a jury. Danka, who pled no contest to failing to report an accident. The case carried weight because the victim was a 5-year-old boy who ran into the street and was struck by her car. Nash admitted to police that she saw him too late and assumed another adult at the scene was handling things, so she left without speaking further. The child had visible injuries and was treated at a hospital, though thankfully they weren't life-threatening. Judge Middleton accepted the plea, but made sure to explain why a no-contest plea made sense here. It avoids an outright admission while acknowledging potential civil liability. He also ordered a pre-sentence investigation and delayed sentencing, wanting to give the child's family an opportunity to share input, even though the case wasn't formally a victim rights matter. That extra step showed the judge's attention to both fairness and the community impact. The overall courtroom was calm, with moments of tension breaking through. Bateman's testimony had a raw, personal quality, her fear and frustration coming out in plain language, while Nash's case brought a somber reminder of how quickly accidents ripple into legal consequences. Judge Middleton navigated both with steady explanations, making sure defendants understood their rights, the implications of their pleas, and why the court couldn't cut corners on procedure. So this hearing gave us one plea that fell apart because the facts didn't match the charge, and another that went through, but with careful safeguards for future accountability. It was a solid example of how the courtroom isn't just about moving cases. It's about making sure the record matches reality. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.